Good morning, everyone, and welcome to the Alliance for Constitutional Sex Offense Laws. My name is Janice Bellucci. I'm the founder of the organization, and I'm its current executive director. The purpose of today's training is, in fact, to help people well, we're going to talk about the petition forms under the tiered registry law, with the goal really, or with the idea that some people, maybe many people, will be able to complete their own forms and will not have to hire an attorney to help them. But then I think also some people are going to realize, as Chance and I go through the forms, that you will need to hire an attorney. So this training today is done by webinar, so it's different than the last training attempt we made. And quite frankly, that is to minimize, if not eliminate, the disruptions that we had during the last training. So unfortunately, what that means for attendees is that you will not be able to ask a question orally. However, if you do have a question, we're going to, you can ask that question in the chat room. And also you can raise your hand if you have a question. We've already had one question, one answer before we even started recording, which is a good thing. So I'm glad that you all are somewhat familiar with the process. I would like to urge everybody to have pen and paper handy, because we may be saying some things that you might want to remember. On the other hand, you can always go back and listen to the recording as well. And then the other thing that you might consider doing is going to the ACSOL website. Just to remind everybody, it's www.all, and then CONSOLAWS.org. And when you go there on the homepage of the organization, what you're going to find out is that there's an article there that talks about this training. And if you basically click on the article itself, what you'll see below the article are all the forms that we're going to be talking about today, with one exception, and that's a brand new form that we just found out a couple days ago. So having said that, again, my name is Janice Bellucci. I'm the executive director of the Alliance for Constitutional Sex Offense Laws. I'm also a civil rights attorney. And with me today is Chance Overstein. So Chance is the president of the board of directors and a criminal defense attorney. Chance.
Good morning, everybody. Nice to see you here. And without further ado, let's get started.
Excellent. So when I talk about these forms, I'm going to refer to them in two different ways. One is by the title and the other is by the form number. So the very first of the four forms we're going to discuss today is the CR-415. So this is called the Petition to Terminate Sex Offender Registration. And we've been waiting for this moment for many years. And here it is. And we have forms and everything from the government. So on the CR-415, the petition itself, I'm going to talk about the first page, and Chance is going to talk about the second page, and perhaps we'll talk about the third page because there's hardly anything on that third page. But if you take a glance at the first page, what you'll notice is there are blanks to fill in. So nobody has to write an essay question here about why you're a good person, a law-abiding citizen, and you should no longer be required to register. Instead, what you're doing is you're giving the first the local law enforcement, and after that the DA's office and the court, some very basic information. So if you look at the number 1 that's in a circle, that's petitioner's information, and they're asking for your name, your date of birth. The B section there is only if you are represented by counsel. So if Chance and I are filing a petition, we have to put our name and state bar number there. And then C, and it says this is important information, right? It says ask for your contact information. So the reason that's important is that, in fact, if the court or the DA's office or local law enforcement have a question of you, the easiest thing for them to do is look at this form and see what your street address is, your email, your phone. Yes, they already have this information, but let's just make it as easy as possible for them, right? So let's put all your basic information here under petitioner's information. Then the next part of this form, it's got the number 2, and then it's got a circle in it. It talks about your registration status and information. I'm going to try not to make too many editorial comments today, but quite frankly, I think this is ridiculous, and I'll tell you why. The only thing more ridiculous is the number 3, but we'll go to this one first. So they want to know where you're currently registered. Okay, what county? So folks, hopefully you know this answer off the top of your head. So just fill in the blank there. The second one is a little more, ask for a little bit more information. They want to know where were you convicted? Okay, so for many people, it was a county in California. If so, you want to put the county there, which might be different, of course, than the county where you're currently registering. And it's also possible you were convicted in federal district court, military court, or out of state. So give them as much information as you can right there, including a case number. Now, it's possible to play hide the ball with these folks, but guess what? Anytime you don't give them complete information, or even longer. So again, you're going to tell on your petition right here where you were convicted of an offense requiring sex offender registration, and then give them even the case number if you can find it. By the way, the case number is not required. It's just an option. But again, I think it will help in the consideration of your petition if you in fact give them a case number. And then C is just reminding you that you cannot file until your next birthday after July 1 of this year. And yes, that means that if your birthday was in the first 6 months or is in the first 6 months of the year, and that's January through June, you're going to have to wait until next year, until 2022. I know I've talked to some people, they said, I don't care, I'm going to submit my petition anyway. If you do that, it will be rejected. And my concern for anybody who tries to do that, that is to submit their petition early, then I think what could happen is the court could in fact make you wait for 1 to 5 a wrinkle. The 2D talks about the proof of current registration. This is important because it's the only document that in fact you're being asked to provide. So if you have a certificate of rehabilitation, if you have a dismissal, do not include that with your petition. This is not the right place to do it. The only place that they want you to submit your petition or submit with the petition is this proof of registration. So I want to let you know that as of this week, in fact, just a few days ago, that there's a new form. And Chance and I both have submitted petitions at this point in time, and we're getting an uneven response. But I will tell you, in one county where I submitted a petition, I was told that the normal, what I call the normal, the old petition, old proof of registration wasn't good enough, and that the registrant had to go back to the registration office and had to go get this new form. And the form number is C as in California, J as in Justice, I as in Information, S as in Sam, 8050. So we're going to add this to the ACSOL website today, but for right now, just know that this is at least one county is requiring, not just requesting, but requiring that the registrant have this form. I will say it's a pretty nifty form. And again, I've only saw it for the first time a couple of days ago. And one of the reasons is it actually has your tier assignment or your tier level on the form itself. So this is something new and different. And again, why we were just told this week about this, I'm not quite sure. I'm going to give the government the benefit of the doubt, which is they don't know what they're doing, because I will tell you that this form is not mentioned at all in the instructions that go, or the information sheet that goes along with the form. So that is that. And as I said, this new form will be added to the ACSOL website. And I think you'll have to ask when you go to register for your annual, or however often it is that you're registering now, you're going to have to ask for this specific form, or you should ask for this specific form. Hopefully the registration office where you go to knows what you're talking about, because we've had that issue that come up as well, where when one part of the government says you must have this form, another part of government says, what form? I've never heard of it before. So anyway, just understand it's a blip. I don't think that it's going to cause great problems in the long term, but it's causing a small problem in the short term. So the last item here on the first page of the petition form is the termination request. This is what I think is utterly ridiculous.
Okay. Carlton. Have we lost Janice?
We lost Janice temporarily, but
all right. Let me go on. Let's go on, and Janice will join us as soon as she can.
Okay.
But let's go to the top of that form for a minute. Let's just say page 1 before we get to the bottom. If we could go to the top and just continue here. One, I want you to see on the right-hand side these boxes. Okay, one is the clerk stamps the date. That's for the clerk in the court that you're going to file at. 2, underneath, it says Superior Court of California, County of. It's just, it is the county of where you are filing this. If you're filing in Los Angeles, that box just says Los Angeles. If you're filing it in Orange County, it says Orange County. Riverside, it says Riverside. Okay, those 2 you fill out. Now, look underneath the case number. This can be confusing because lower down towards the bottom, it asks you for the case number of your conviction. This should be the case number of the court, of the particular court that's going to hear this case, which means they should generate a new case number. That's why it says court fields in case number when form is filed, because you should be assigned a case number there. So I don't think you need to worry about that. And again, below that, date, time, and department, that is for the court only. Okay, when you file it, they will assign the date, time, and department. Now, go down to the bottom to 2, Carlton, and you'll see that it says 2B, identify the court in which petitioner was convicted of an offense requiring sex offender registration in California. Now, it says specific California Superior Court and so on. And if known, include the case number of the conviction. Okay, so just follow exactly what the instruction says. If it was in a state court, just put California Superior Court and then put case number and the case that you were convicted on. Very, very simple. And then towards the bottom of the page, item 3, termination request. Of course, you're going to check that box because that's what this application is all about. All right, let's go to the second page, Carlton. Okay. Now again, see the top box there? It says case number. Okay. Take a look at that. That again is assigned to the new case, not the old case. So that should be generated by the court when you file it. Okay. That should not be the conviction case number. Okay. Pending charges. Okay. Take a look at that. That means that if you're filing this thing, okay, you have no other charges, criminal charges pending at the time. There should be nothing. So it means what it says. To your knowledge, there are no pending charges against you. Okay, that could extend the time to complete the registration requirements. That's part of what this is. If you have pending charges, you're not eligible. Custody status, that's pretty easy. Okay, and self-explanatory. Supervision status. Okay, you're not on parole, probation, or post-conviction supervised release, or any other form of supervised release. Pretty self-explanatory too. That simply means that you are free of conviction, of pending conviction, or monitoring through the criminal justice system. Okay, tier designation eligibility. Okay, take a look at this because this is interesting. You know. Most of you will know your designation or get a letter telling you which tier designation you are. Some of you will get to be determined. Now, we really don't know how to operate here exactly because you don't have a box saying to be determined and a checkbox to say, oh, how many years have you registered? What I've done, and just recently in a filing I did, was the first question, petitioner was, or the first thing under tier designation and eligibility is petitioner was designated by the Department of Justice for the following tier and registered for the following number of years. What I put is just TBD, okay? And then what I did is I checked the number of years that they fall into under, okay? And the reason I did that was because it has to be true and accurate. And if you're not designated by the Department of Justice and it's TBD, then that's what I would put. And I would just check, like for instance, in the case where I put TBD, I just checked petitioner is registered for at least 20 years. It's under tier 2. It doesn't necessarily mean that that's going to be tier 2. It just means that's the number of years the person is registered. So I'm again, this is all new. So, you know, but in filing it, when the court checked this out before they stamped it, that was fine with them. Now, will it be fine? I don't know, but that's how I'm operating because I'm not waiting 18 months to file it. So I'm doing it now. Okay, now go towards the bottom. And I think all these tier assignments are pretty clear. If you've got a designation and there's a box to be checked, check it. And there are many boxes under here, but you will fall into one of them. If you don't know exactly, if you know, for instance, if you're in a tier designation and you don't, let's go to tier 3, for instance. Carlton, just roll up a little bit. If you're in tier 3, okay, and you don't, okay, so it says petitioner's designation is based on a risk level assessment. Okay, so maybe you should be in tier 2, but it's elevated because you have a high risk assessment. That's the box you check. If you don't know which one of those you're in, okay, then it's time to consult with an attorney before you file the application, because if you make a mistake, it's just going to be jettisoned. So you want to know exactly where you fall and what it is. Okay, go towards the top of that again, Carlton. Let's just go back just a step. Look at the designation and eligibility again. Tier 1 adult, pretty straightforward. Petitioner is registered for at least 10 years. Okay, 2, tier 2, registered for at least 20, or, and notice the or is in bold. And now you have these different things, okay? And you go through those. Petitioner, you know, it's registered for at least 10 years and all the following apply, okay? And roll down a little bit, Carlton. You see these 3 things here, okay? It gets a little bit sticky because look at B. Petitioner has not been convicted of a new offense listed in section 667.5 sub C, violent felony, since petitioner was released from custody on the offense requiring sex offender registration, and, okay, and the offense for which a petitioner is required to register as a sex offender in California, 1, and you have these really specific items. This is the time that you may want to consult with an attorney, because these things are very specific and it's hard to really determine. I mean, if you look at the bodies of laws, it's you've got to go through, you know, things, objects, you know, statutes, and figure out what's what. There's a lot of stuff in there. So what you want to do, I think, if you're in that area, if you're in tier 2 and you fall into one of these, you know, boxes, before checking off one because you're guessing, don't guess. If you don't know, consult with an attorney so that you're accurate. Same thing goes for tier 3. Roll down a little bit. Carlton, okay. And you look at this again, tier 3. There's stuff here. For instance, Penal Code section 1192.7C, serious felonies on item 5, C5. Okay, unless you're familiar with that statute, you can make that out. You may not know what that means. So these are where complications happen. It would take a long time to open up the penal code and start to go through these things, and it would be confusing, and I don't want to confuse anybody. You know, simply to say there are, you know, if you fall into the easy stuff and you know where you're at, you know which box to check, tier 1, 10 years. But if it gets complicated or you don't know, time to consult with an attorney. And I will say this, in terms of that, before you consult with an attorney, there's 5 things to know. And Janice, are you with us again? Okay. It's kind of freezing there. 5 things to know. Okay. 1, know when you were placed on supervision and or released from custody, and approximate dates of sentencing and release. Okay. And if you're going to consult with an attorney about issues in these boxes are, things that you may not know and you want to know because you want to apply. It's important to have your pre-sentencing report, okay, which is prepared by probation. 2, you might want to have your sentencing sheet. And 3, an electronic docket of your case. That will help an attorney help you understand whether you fall into one of these categories. 2, request, if you haven't already requested your tier assignment, please do so. And you do that from the agency where you register. You also want to, obtain proof of current registration. And that's something Janice talked about, and there's a new form, and that's important. So you might want to follow up on that, because if it's being rejected because you have proof that you registered a hard copy and it's not the proper form, you don't want to lose out on this. You want to make sure it's done on the proper form. And also, you want to obtain a live scan. Okay, a live scan is your criminal history. You go to a UPS store, you can request a live scan for your, for personal reasons. And that also helps, because when you start to look into these different bodies of law, there are specific offenses listed. And if it's on your live scan, it's easier for an attorney to then tell you, you fall here or you fall there or otherwise. And also, know your risk level if one has been determined. Know if you've done a static 99 or a stable 2007, or know what those scores are. See if you can get copies, or at least know what they are when you speak to an attorney, so that you can discuss risk levels, and you can talk about it. And also, if you have any comprehensive psychological evaluation or risk assessment available that's done outside of the formal procedure of probation or so forth, provide that to an attorney so they can do a comprehensive look at what needs to be done, or whether or not you are eligible to apply. Also, previous petition at the bottom of the page. If that's pretty straightforward. None of you will be checking that, because this is a first-time deal right now, and so we're all starting out. So don't be too concerned about that. Don't be concerned about it's been denied, or counting and so forth. That's not an important thing at this point. Okay, Janice, are you with us?
I think she'll be back in a moment.
Okay, shall we just move on to the bottom here? Okay. All right. Registration period. Okay, petitioner believes that they met the requirements to register for the time period required by petitioner's tier designation as determined by the Department of Justice. Okay, if everything on that application is correct, check the box. You're declaring that that's all true and correct. Date it. If you're doing it yourself, your signature is required. If not, your attorney signs it. And that is it. Carlton, do we have questions?
None that weren't answered. There was a question about how to handle Section 8. You explained that.
Okay.
Really, there's consensus of the first petition.
Okay, back to Janice.
All right, thank you, Chance, very much, and thank you, Carlton, for putting that form up. Before we move to the next form, there's just a couple of things that I'd like to emphasize that Chance said, but folks, this really bears repeating. If in fact you're in custody, or your loved one is in custody, I've already got this question from family members. When the person's in custody, they cannot petition for removal from the registry, even if you're in custody for something other than a sex offense. So if you're in custody, the answer is no, you cannot submit a petition. Also, if you're under supervision, and that means parole or probation, includes those two things, supervised release, you cannot submit a petition. If you try to submit a petition, actually, if you do submit a petition, it will be rejected for those reasons. And folks, just save yourself the grief, save yourself the money and the time. Don't submit a petition when you know that you're not otherwise eligible. So in just a moment, I'm going to ask Carlton to pull up the form here for it's the response by the district attorney. and that's the CR form -417. You all might want to pull it up too if you have it available. So in the process, you wonder, what happens after I submit my petition? And the fact is, it's going to be reviewed by 2 different levels, and then it goes to a court, to a judge for review. Interesting thing is, the first level, which is your local law enforcement, doesn't have a form. So we really can't speak to that, other than to say that they are supposed to determine, local law enforcement, whether or not you're eligible. So when you talk about whether or not you're eligible, do you have the, but even if you did, it bears repeating. When you start counting for the time that you can, in fact, qualify under the tiers in that, it's whenever you're released from custody. That's both good news and bad news. So it's not when the offense occurred. It's not when you were convicted. It's not when you were sentenced. Okay, it's not when you're in custody. None of those qualify. The clock starts when you are released from custody. But the good news is, it's not while you're on, that the time that you're on supervision, parole, probation, supervised release, that does in fact count toward the minimum number of years for your eligibility. If you were truly convicted as a juvenile, this process doesn't apply to you. These forms don't apply to you. And I don't want to dwell upon that. Okay, so again, once local law enforcement determines that you're eligible, they're supposed to basically share their finding, we'll call it a finding, with the district attorney's office. So here we go. This is the DA's formal response to your petition, and it's in the form of a form. So CR-417. Okay, so when you look at this, some of that is just really basic, but if you go down, the DA has no objection to this petition. Folks, if you get that box checked, chances are you're going to get your petition granted. It's not an absolute guarantee, but it's pretty darn likely. Okay, then, but you look at B here, that the DA is objecting to your petition and requesting a hearing. If this response from the DA's office gets checked, that's when you need to contact an attorney. Okay, there's going to be a hearing. It's going to be in court. It will be contentious. There will be evidence presented against you. And this is what, please, please, please do not go into court representing yourself, because you will have an assistant district attorney on the other side who will not have your best interest in mind. And you need a legal professional like Chance or I, or there are others out there as well, that can in fact represent you and get you prepared for this. Okay, so let's look at the 2 reasons. One of them, this 2B1 in parentheses, community safety would be significantly enhanced by the petitioner's continued registration. This is what I fear most of all, and I'll tell you why. There's no definition here. We don't have any factors here. There's no case law. What does this mean? Community safety would be enhanced, right? By requiring you to continue registering. I'm really, really concerned about this. But the fact is that if there's a hearing, we can certainly speak to that and do our best to persuade the judge that despite what the DA has questioned, that in fact, the community safety won't be enhanced by you continuing to register. And trust me that both Chance and I, we know a lot of reasons that we can give to a judge. That's my one concern about attorneys who don't work with registrants on a regular basis. They don't know these reasons. But folks, it is what it is. So just think carefully about who you hire to represent you in a hearing like this. But again, my overall recommendation is do not go into one of these hearings without an attorney. Okay, so that's another option that the DA has to choose. But then C here, look at all those reasons. I mean, we're going down, there's 8 different reasons that the DA can ask that your petition be summarily denied. I guess that actually is worse than B. And the reason it is because if in fact the DA ask for summary denial, that means there will not be a hearing at all. All right, so you will not be able to get in front of the judge or your attorney and plead your case. Instead, there's going to be a judge. If the judge agrees to this recommendation, then there won't be a hearing. Your petition will just be denied. Now, they've got some, very specific reasons here. They've got some very specific reasons here, and so maybe those reasons do, in fact, apply. And I don't know if I'm being recorded or not, if anybody can hear me. So I'm going to pause
Yes.
to rejoin. Can you hear me?
Oh, yes. No interruption.
Okay, that's good. I can't see myself, but maybe that's a good thing. Okay, so we keep going here on the responses and that. But if you look down, so there's some very specific responses, including, of course, the one that I don't, that you haven't fulfilled the filing and service requirements. Let's look at that, filing and service requirements. That means that your petition basically is not properly filed with the court. That's a big deal. Okay, the service, Carlton is going to talk about proof of service toward the end of this webinar, because that is important too. You need to serve the right parties before your petition can be heard. And there's these other reasons too. Look at the C3, that you're in custody or you're on parole, probation, or supervised release. I mean, Chance and I have talked about these other things, which to me are reasons and they're not excuses. The thing that bothers me though is number 8, which is other. So think about it. The DA, after looking at your petition and only your petition and your registration form, right, is going to recommend to the judge that your petition be summarily denied for some other reason. And I'm expecting some county DAs to be very creative here. I don't want to borrow trouble, but you need to know about that in fact, that DAs are going to have a lot of discretion here about rejecting your petition. So that's really the end of the form. By the way, both local law enforcement and the DAs each have 60 days to make a recommendation about your petition. Those are not concurrent. So in other words, the local law enforcement gets their 60 days and then the DA has another 60 days before there is, goes to the court, and the court is then making a decision again, whether or not to grant or whether to deny your petition. So to get to the Wizard of Oz here, the Wizard of Oz, that's the judge. It's going to take at least 4 months. I'm concerned too that DAs quite often request extensions of time. And so we may have some DAs who are requesting extensions of time. And I'm not sure if anything can be done to negate that. But hopefully you will be informed of that and you'll have an opportunity to dispute it. But on the other hand, maybe sometimes it's not a good idea to disagree with that, because if the DA is going to cause trouble, maybe they'll cause more trouble if in fact you dispute things. So Carlton, at this point in time, do we have any people asking questions about this form, the DA's response?
No, and if you have a question, you can either use the chat function or there's another option called Q&A at the bottom of your screen. But no questions yet.
Excellent. Okay, we're doing such a wonderful job, Chance. No questions.
Okay.
So I think the next form to talk about is this order on petition to terminate the sex offender registration. That form is CR-418. And Chance, if you would take that up.
Okay, let me just turn to that real quick. Okay, order to, okay, simple. I think that, again, simple order, name, birth date, name of attorney, and mailing address. Okay, most important part on this form is the court grants the petition to terminate sex offender registration requirement under Penal Code Section 290. That's wonderful. And if you get that box checked, congratulations. That's perfect. Okay, I wish box 3 wasn't there, item 3 wasn't there, but item 3 is there, and we've got to deal with it. Okay, the court summarily denies the petition to terminate the sex offender registration requirement because, and that's what we were talking about, the last form and things like that. So again, it has to do with the service requirements. Did you do everything properly? Okay, that's A. 2, there are pending charges somewhere, someplace. When they did your background check, when the DA did the background check, they found pending charges, and that causes delay. 3, some form of custody, or you're still on parole or probation or supervised release. So, and this could even be summary probation for a DUI or petty theft or anything like that. You've got to be probation free. You can't be under supervised release. Okay. 2, you don't qualify because you're in tier 3 as a lifetime registrant, and you don't fall under the risk level exception. And that's what I was talking about, having this analyzed and having an attorney look at this beforehand so that you know whether or not you fall within that exception. Okay, and that's another thing that can eliminate you from consideration and removal. You're on tier 1 or tier 2, and you have not met the mandatory minimum registration period for that tier. And it's pretty clear, 10-year period, 20-year period. And you got to know when that begins and ends. And you've got to be approximate in that. Otherwise, it's going to get this checkbox, and you're going to end up having to do a little bit more time on the list. Petitioner is in tier 2, but has not met the following criteria for a 10-year exception. And that again gets into 290.5B1 and 2 analysis for an attorney. A good time if you're in the weeds and the bushes there to consult with an attorney about that. Okay, and petitioner is in tier 3 solely on the basis of risk assessment and has not met the following criteria. Again, something that has to be analyzed and looked at. Because these, there is wiggle room here and there's flexibility in interpreting these things, and it should be done, by way of an attorney. That is my supposition. And then the box other, and that's the one that Janice was talking about. We don't know what other means. You know what other means, Janice?
I do not.
Yeah, I don't know either. Until we get there, we don't know. So we can't anticipate. This is the pioneering effort. It's just starting off, and so we're going to find out what other means if it's ever used. We don't even know if that's going to happen, and so that pretty much completes CR 418. Janice.
All right. Well, actually, that completes the first page of that form. I'm going to go ahead and do the second page. So, Carlton, if you would go to the second page, that would be great. So, on the second page here, this is more about, or more includes more reasons now for the court to deny your petition. Okay. And 1 has not met the requirements of Penal Code Section 290, parentheses E, that is the tiered registry law. And 2, community safety would be significantly enhanced by the petitioner's continued registration. So I'm just, it's so frightening to me, and I'm not even on the registry, this term significantly enhances, because we have no idea what that means. And like with certificates of rehabilitation, we've had those for many years, decades actually. And during that process, there have been court cases out there, and in the court cases, courts have in fact interpreted what certain terms mean. But because this is a brand new law that's being implemented for the first time, there's no case law here. So maybe that term significant enhancement can in fact be used or has been used in some other cases. We'll be sure to research that. But again, that's to me very very frightening. And then if you look again under, so it's 4, then B, and the judge has to check a box here. Either it was stated orally on the record why this will be significantly enhanced, or set forth below. I'm afraid when it says stated orally on the record, because these days there's not always a court reporter available when a judge makes a statement like this, and I would just be very concerned. I would just be concerned that there might be some mischief, and that's being kind. Okay, so let's just say if in fact a judge does deny your petition, well, when can you return? Well, first, can you appeal it? That answer is yes. But then it's like, well, what if you decide not to appeal? How quickly can you get back to court? And look at this. It's the number of years that you have to wait depends upon what tier you're on. So here it says if you're on tier 1 or tier 2, it can be 1 to 5 years. You might have to wait 5 more years before you can come back in and petition again. So folks, this is why Chance and I are emphatic in saying you've got to dot every I and cross every T here when you fill out your petition, because it can be denied and then you'll have a long wait possibly before you can resubmit. So then it says for tier 2 here, if it's based on the 10-year exception, then I don't know why it says blank years. I believe this can be 1 to 5 years as well, but we'll see. But maybe the difference here, chances that there's some discretion, but at least it's going to be 1 year. It could be up to 5 years. And then here for tier 3, if there is a denial, then it's going to be at least 3 years before you have to wait again. And I just, again, am very concerned in some counties, where we have, some people say conservative judges. I don't want to say conservative or progressive or any other term. We just have some judges who really worry about whether or not they're going to get reelected, or even if they could get recalled, like the judge who basically ruled in the Stanford case. So please remember that, folks.
Okay, I think we lost Janice again. Carlton, did we?
Momentarily.
Okay. Shall we move on to the process of service of process? Shall we do that?
Okay, we can do that, or answer a few questions perhaps, because we had several about this form.
Okay, absolutely. Which form are we talking now? The one that Janice just was doing?
Well, one question was about CR 418, which we just talked about the order, and then also CR 417, the district attorney form.
Okay.
And the question is, do registrants need to partially fill those out and file them, or are you just showing them the forms?
I don't think we need to partially fill them out and file them. My supposition is these are just for the court and the DA's office.
Okay. And on both forms, there's a reference to the petition being denied because the registrant didn't satisfy the requirements of 290 sub E. What does that mean? 290
sub E. Okay, I'd love to dig into it right now, but now's not the time.
Primarily, I think it just has to do with they didn't register long enough.
Yeah, yeah. Oh, we got Janice back. Here we go.
Hello, everyone.
Okay. So I don't know if you heard the question that was posed about CR 418 and 417. Carlton, you want to restate that question for Janice?
The question was those two forms, the proposed order and the district attorney form, do registrants need to partially fill those out and file them or not?
I would say not. The petition, if you look at the instructions, there's no instruction there to submit these forms along with it. I'm not absolutely sure of this. One county has told me that they're filling these forms out in a government-only database. So I don't think that we have to do that. And I don't think that we should do that. I don't think when you all submit the petition, if you're submitting it on your own, you just submit the petition, right? That and proof of registration, that's the only thing that you submit. So the rest of these forms are for the court or DA's office or the local law enforcement to complete.
Okay, Carlton, question 2.
And there was a question, can we clarify what does it mean to have the petition denied because the registrant didn't meet the requirements of 290 sub E? That's an option on both of the forms, the order and the DA's form. I think it has to do with tier, you didn't register for long enough.
Yeah, as far as I understand, the 290.5E is basically the new law, the tiered registry law. So it's very vague, shall we say. In other words, it could be for many different reasons.
Yes.
And there's a question about timing of the filing, if you had the choice, is it better not to file it during something like a district attorney election cycle?
Oh dear. Well, that's actually a good question. But I would imagine it's up to you. I don't know that I would be worried about the politics. Remember, from the time that you submit the petition to the time there's an answer that comes out the other end, it's going to be at least 4 months. So it's up to you. But I think that maybe part of the message here is to remind everybody, you do not have to submit on your birthday, your first birthday after July 1 of 2021. You can wait if you wish to. And so it could be for political reasons. It could be for any other reason that you choose. I know that there are some people who are waiting before they submit their petition, even though they're otherwise eligible, because they want to see how other people fare under the petitioning process. I kind of understand that, but I mean, it's such a wonderful goal to achieve that I would tell you, if it were up to me, I would just go ahead and petition as soon as I can, and not believe that, you know, what's happening is going to, the ultimate answer is going to be based on politics or anything else. Having said that, if you have a pretty long rap sheet, you really should talk to an attorney about that. And let me tell you why I'm saying that. I looked at somebody's live scan report yesterday. It was 11 pages long. I've seen longer ones, but that's on the long side. And in that 11 pages, he was accused of, you know, multiple felonies that are not sex offenses, but also sex offenses, right? And I looked at that person's rap sheet and I said, you know, if I were the judge, I wouldn't grant this petition, right? And he's not eligible anyway because he's on tier 3. So at least for now. So folks, I mean, think about it. If you're going in and out of prison, if you have multiple felonies after your sex offense, it's unlikely that a judge is going to grant your petition. Maybe you need to know for sure, and that's why you submit your petition. But I would say that if you have a long rap sheet, it's probably a really good idea for you to get a lawyer to represent you.
Agreed.
Another good question. If somebody is convicted and released, and then they've been living in another state and they registered there, then they move to California, is the time they spent in the other state, does that count toward the minimum registration period if they want to petition in California?
We don't know. I will argue that for sure. If you're my client, I'm sure Chance would do the same thing, but it's different than certificate of rehabilitation. In certificate cases, you had to be in the state for 5 years prior to submitting your application for a certificate. It does not say that here under the tiered registry law, at least not yet. So I would certainly go ahead and submit my petition if I were you. What do you think, Chance?
Yeah, if you have residence in California, I think you're eligible. I don't read any time requirements, any rollover requirements. The law doesn't speak to that. So, your time is your time. So if you live out of state and you want to reestablish in California, you've done the time, file the petition.
There are a couple questions about the birthday rule. So for example, if my birthday is in September coming up, do I have to wait until then to file?
Yes. I'm not sure why that's even a question, but yes. So folks, you have to wait at least until your birthday. Okay, not even the month of your birthday. And the thing is too, with this current registration form, they're not going to give it to you anyway until you're properly registered. And you're not going to be able to register until it's 5 days before, 5 days after your birthday. Those are business days, by the way.
And I believe we've answered all the other questions, or I know we will in my presentation.
Okay, great. All right, so folks, and some of these forms, when we talked about the judge's order or we talked about the DA's response to your petition, one of the things that it basically talked about was filing the petition properly and getting it served properly. So we've asked Carlton to speak to that today because he's been very directly involved in that. And if you don't do it properly, then in fact the court can and probably will reject your petition. So please, Carlton.
Sure. So I'd like to show you another form first, which is the instruction form. The Judicial Council has provided a set of instructions for what you need to do in terms of filing the petition and filling it out, which Janice and Chance have just gone through. It's CR 415-info. And you can review this on your own. It's pretty detailed. But down toward the bottom, on the second page, number 7, who else gets a copy of the petition and proof of current registration and how? And that's important because filing the petition with the court in the county you're currently registered is how you start the case. But simply filing the petition and proof of current registration doesn't tell the district attorney or law enforcement that you filed a petition. You have to actually give them a copy of those things to let them know that you filed this petition and that they need to respond to it. And that's called serving the petition. And so the instructions are in section 7 here on the info form, and I won't go through them on this document. You can look at it yourself. But let's go over to the proof of service. Hopefully you can see that. Is that showing up? Okay, great. So the deal is this. When you take your petition and proof of current registration to the court, you should bring another copy. And they will probably give you back a file stamped copy with the court's name on it and a case number. We've seen that happen so far. They might not do that. Sometimes it takes a while to turn it around. But if you get one with a case number, you should make some copies of that face page with the case number. Then what you need to do after filing the petition is to serve it on at least 2 organizations. First, on the district attorney in the county where you're registered, and second, on the law enforcement agency where you go to register, the police department or the sheriff's department. And you can serve in 3 different ways, which the instructions go through. The best one is to personally serve it, meaning you just walk there and you give it to them. And and that's the best way because often you can if you bring an extra copy, you can ask them to stamp it received so that you have a record that you in fact brought it to them, to the district attorney and to law enforcement. You don't need to be afraid to do that because certainly the district attorney, when you serve papers there, they have somebody who sits behind a window and accepts service all day, so they'll just stamp it and give it back to you. Law enforcement may be more interesting to find somebody who will accept it, but nevertheless, the law requires you to serve it there, so they should accept it, and you can explain what you're doing. You're serving a copy of your petition and ask them to stamp it. If you don't want to personally serve it, you can serve it by U.S. mail, and you can obtain the address for the district attorney and law enforcement on the internet. If your county, the internet will tell you where the district attorney's office is located and their mailing address. And if you live, in a city with a single police station or a single sheriff's department station, you can serve it there by mail. The instructions say, however, that you should call both of them to find out what the proper mailing address is or the proper person who should receive it. You can put attention that person. That's to minimize any delays that will come up if you mail it to, say, the Los Angeles County Sheriff's Department, which is a large department. So, them saying, well, we didn't get a copy. And the third option in terms of delivery, the instruction says electronic service, but you can't just email your petition and proof of current registration to them. You need to obtain from them permission to do that and an email address. And keep a copy of the email that you send them, and hopefully you ask them to confirm receipt. That's a little iffier. You can't just email people. They have to consent to receive service by email. Once you've done that, served your petition and proof of current registration on the district attorney and on law enforcement, you fill out this form, CR 416, the proof of service. And I'm showing you one, oh my goodness, well, that I filled out. And number 4, it just asks you to, if you mailed it, to write out the address you sent it to. And also the same for the district attorney down there. Now, questions come up. If you're convicted in the same county where you currently live, this is much easier because you only need to send it to the district attorney and law enforcement in the county where you register, because that's the same one you were convicted in. If you're convicted in a different county from the one you currently live and register in, you need to send the same petition, the same proof of registration to the district attorney in the county where you were convicted, and also the law enforcement agency in the county where you were convicted. And so the same process applies. You look up what the mailing address is, or you can physically bring it there if you feel like making a trip. And you write out the address here, and you sign that you did it on this day. And you also, once that's done, you file it with the court. Of course, that will be after you file it with your petition, so it'll be a separate trip to the court. But this proof of service declares, for the court that you complied with the obligation to serve the petition on those agencies, so that they can then take it and respond and provide the information they need to provide.
Okay. Any questions about that?
No, I would just like to add, though, that based upon our experience already, and it's less than a month in, that it can be confusing for anybody, attorneys or non-attorneys, to figure out all the places where you need to serve. And so I just, give it some thought, some very careful thought, folks, about who you need to serve. If you were convicted in the same state that you currently reside in, trust me, things are so much simpler. But if you can't control that necessarily. So if you live in a different county than where you were convicted, then in fact, things get more complicated. So I think I'll just leave it at that. But again, folks, I know that this is not a perfect process. It's a process that's just started, and I know we've already hit a hiccup, and that is this new registration form that we were currently not aware of. By the way, the date on the form is July of 2021, so that is this month. So this is a brand new form. And again, it's more than a little confusing, because in the information, all these forms we got from the Judicial Council here in California, they never mentioned once that they were going to change this proof of current registration form, or that there would be a new form. So be on alert that there's a new form. And again, it's CGIS, the number 8050. And so when you go to your registration office to get your registration updated, please ask for this form, because that's what you're going to need when you submit your petition.
That may be the single most important thing you take out of this today, because if they generated that form and you're attaching a hard copy showing current registration, and courts are going to be sticklers for forms, what Janice just said is going to eliminate a lot of problems for you.
Yeah, thank you, Chance. So I think maybe there's one question, Carlton.
Yes. What if your conviction was not in California, it was in another state, or say it was a federal or military conviction? Who do you serve with a copy of the petition and proof of current registration?
That is a really good question. I think you do your very best. I would just think if military, you send it back to the military court that convicted you. And they may have no idea what to do with it, but at least you can let this court know that you've done that. You've sent this notice. Chance, it makes me think about the certificates of rehabilitation too. And they had a situation there that if you were convicted in a different county than when you currently reside, then you had to notify the county where you were convicted. And I can't, in the certificate cases I had, I don't remember even one time that the county of conviction weighed in. How about you? Did you have any?
Only once.
Okay.
Only once, and I remember very clearly, because it happened in Modesto. And it was so funny because they did show up and they left their opposition, and the DAs on the floor at that time notified me of it and advised me that they had filed it in the circular file. They dropped it in the trash. That was it.
Okay.
That was it.
So folks, the reason that I'm sharing this with you is because some people are so afraid, you're convicted long ago and it was a painful experience and maybe even have some PTSD in that superior court. I understand. But at least in the past, it hasn't made much of a difference, if any difference at all. So it's really much more the county where you currently live. And so here's my commercial about Orange County. If you currently live in Orange County, I recommend you move. Okay. Why do I say that? It's not because I hate Orange County. I used to live there. I went to high school there. But the fact is that Orange County, with only one exception that I'm aware of, has never granted a certificate of rehabilitation, regardless of the person's circumstances. And I doubt they're going to grant any petitions either. So it's up to you. And to share a story without mentioning my client's name, I had a client who lived in Orange County, and I warned him about applying for a certificate of rehabilitation there. At least he listened to that part of my recommendation. It took him 2 years to decide to go get an apartment in LA. And once he got his apartment in LA, 6 months later, he had a certificate of rehabilitation. So folks, it can be that easy. I know it can be financially painful, but it's up to you. How painful is it to remain on the sex offender registry? You're the only person who can answer that question. So Carlton, I think maybe we have another question.
Yeah, there's a couple that are related. They're asking about the form number for the proof of current registration. And
here we go. The form number is CJIS, 4 letters. C as in Charlie, J as in Juliet, I as in India, S as in Sierra, and then 4 numbers, 8050. So CJIS 8050. The name of the form is Proof of Current Registration, and it's dated July of 2021. It might be possible to get this on the website of the California Department of Justice, maybe. But again, we will put it on the ACSOL website. The only reason it's taken this long is we have to I have one form that's filled out, and we need to redact the information before we put it on our website.
Should we though expect that if this is operating perfectly, that law enforcement would have and fill out and give us that form without us having to bring it, or should we be prepared to bring a copy?
That's a great question, and I really don't have an answer. In the one situation that I mentioned earlier this week, the registrant had already gone in to register. He gave me that multi-page, I think it's up to 7 pages now, his registration document, and we had submitted that with this petition. And basically, he was told by the registration office he had to come back into the registration office and get this other form. So they had it there. I think it's something, again, that's in a government database. I don't think it's, I don't think we private attorneys have the blank form. But I don't know, maybe we'll go look for it online. But I think basically you go to the registration office and you ask for this form. My concern is they're going to say, what are you talking about? I've never heard of this form. And I think maybe one of our attendees has found the form. Thank you, Dave, for giving us a link there in the chat room. So go there, folks. Again, this may not be required in every county when you submit a petition, but it's already been a tripwire in one county. I'll just mention the county. It's Placer County. So up here in Northern California, Placer County said that the registrant had to have this form completed in order to add to his petition. The good thing is they didn't just go out and reject his petition and make us start all over again. The fact is they said, oh, come in, we'll give you the form. And think about it, folks, how ridiculous is this, right? So the registrant has to go to the registration office to pick up a form from the registration office to turn around and submit it to the registration office. That makes no sense to me, but this is not always a logical process, is it, Chance?
No, actually it's not, and I'm sure it will be worked out through time, but a lot of this is just doesn't make sense at all.
Right. So it looks like we might have some more questions. or comments?
Question about if law enforcement is not telling you your tier assignment, and or they don't have the letter, the tier assignment letter, what can be done?
Well, I think you would have to talk to a legal professional. I mean, you can guess for yourself what tier you think you're in. And remember, it's based upon the offense for which you were convicted. And we totally understand you may not have done that, but the fact is that's probably what you pled guilty to. And such, so that you need to figure out for yourself or have legal representative tell you give you an educated guess. So you have a guess. The next higher level is an educated guess. The higher level above that, of course, is a letter from the California Department of Justice. Folks, every registration office has your tier assignment letter. They may not give it to you, but they have it. If they deny you your tier assignment letter, call me, 818-305-5984. Again, 818-305-5984. The California Department of Justice put these letters in a government-only database on January 1st of this year. Okay, you don't have to wait for your birthday. You don't have to wait for a rainy day, a sunny day. All you have to do is go into your registration office and request it. Okay, now be kind about it, be polite about it, but the fact is you are due your tier assignment letter. And again, if you go to your registration office, they deny you the letter, call 818-305-5984, and I will intercede on your behalf and get you your tier assignment.
Okay, I'm reading a question. I'll seek some clarity on what that one means. Other than that, we have no more questions pending.
All right. Well, somebody did make a comment, or it was, the comment was, I want to move out of state. What's going to happen if my petition gets granted and I move out of state? And here's the answer. It depends. It depends on the state to which you're moving. Okay. So every state has its own registration laws. And I say they fall in two different categories. That's the broad picture. So one group of states basically says if you're required to register in the state where you were convicted, you have to register in our state too. That's one group of states. The other group of states says we don't care if you have to register in the state where you were convicted. If you committed an offense for which there's an equivalent in our state that requires registration, you'll have to register here too. By the way, California fits in that second category. So if you were registered and convicted in another state, and I know this because I looked at this a few years ago for a man who was convicted in Texas and he was considering moving to California. And I looked at his, we talked about what he was convicted of. I said, look, if you move to California, you're going to be registering for life. And in Texas, he was going to be able to get off their registry in about 10 years. And he was about the 10-year mark. And I said, if you come to California, you'll be required to register for life. Make your decision. Okay, I just gave you a fact. Now you make your decision based on that fact. So if you're going to move to another state after for the lucky people whose petitions are granted, and by the way, I think all of you should be lucky. The fact is, then you have to contact a legal professional in the other state to find out about whether or not you'll be able, or be required rather, to register in that state. Do you want to add something to that, Chance?
No, I think that's absolutely correct and good advice.
Remember, folks, Chance and I are licensed only in the state of California. So we're not going to hazard a guess as to if you want to move to this state, that state, or another state, whether or not you're required to register there. I have referrals in many states to attorneys. I'm happy to share those with you. I'm not putting them on the website because I don't want those people to be harassed by people who don't support our cause. But the fact is, I will give you that information. But Chance and I are not going to tell you what state to move to. Thank you.
Okay, where are we? Any more questions?
I think Carton was asking for a clarification on one.
Yeah, I didn't receive it yet.
Well, I'll tell you what, let's just wrap things up here. And then if somebody has a question, call that number 818-305-5984. That is this ACSOL switchboard. I want to thank everybody who participated in today's webinar. I'm sorry that we couldn't take questions orally, but as you all know, that we were disrupted the last time we tried this training using a different method. But I think that we've had a successful training today. It is and has been recorded, and it will be available for others to use at a different time on a different day. Thank you.
Thank you very much.
Take care, everyone. Bye-bye.